Okay, so what we're going to do is talk about the new changes in the Privacy Act. Now, the Privacy Act has been a long time in the coming, and we will talk a bit more about that shortly. But I guess, first of all, why are we changing the Privacy Act, and why is it important now? So, globally, a lot of stuff has changed in the privacy area in about the last 5 years. So some key changes we had was the introduction of the GDPR. Now that is the European privacy legislation. And that impacts on companies, organisations in Europe, but also some companies and organisations in New Zealand, those doing business with Europe, or those who are targeting or tracking European residents. Other things that have happened off the back of that is there was such a groundswell of work to do GDPR, etc., for companies that other states have seen, or other countries have seen the benefits, etc., and have followed suit. So now what we have is we have GDPR that was implemented for Europe. In the UK, we have the Data Protection Act. It's a carbon copy of GDPR. But also we see California, Nevada, Washington, India, China, all putting in privacy acts that are very, very similar to GDPR. Now, the other thing that has changed remarkably over the last few years is the additional technology that has become available. So, Internet of Things, big data, biometrics, and social media have all absolutely exploded over the last 5 or 6 years. And those bring with them a lot of challenges and potential opportunities in the privacy space. So where do we come from? We have had a Privacy Act in New Zealand that dates back to 1993. So at the time when we wrote the Privacy Act here in New Zealand, we didn't have social media, we didn't have Twitter, we didn't have LinkedIn or Facebook. So it was written around the time when we still had mainframes as a predominant source, etc. It has come on a long way since then. Now, it became quite apparent back as far as 2011 when the Law Commission reviewed the Privacy Act that it was no longer fit for purpose. Technology had advanced, but also the rest of the world has started to advance without us. So back in 2011, they started work on getting a new act done. It had some slight tweaks to the act in 2013, another one in 2014, but nothing substantially has changed. Then, back in 2014, the Minister at the time of Justice announced that we were going to have a Privacy Act that year. Needless to say, we're still debating it this year. So in terms of the Privacy Act, we have come a long way. The Privacy Act is now sitting, waiting for its third reading in Cabinet. In theory, if you look at the Cabinet order list for today, maybe tomorrow is the day for the final reading to make this new bill into law. If it comes through, and all expectations are it's going to kick in on the 1st of December this year. And that means that it will take effect from that date. So you've got between now and the 1st of December to get ready and prepare for it. However, even then, the Commissioner has said their idea is not to take serious enforcement action straight on the 1st of December. They want to work with people to do the right thing. And they understand that some people will not be fully ready by the 1st of December. But they need to have seen great effort to get there. So, what is changing with the Privacy Act? So, Chris mentioned mandatory breach reporting. So, this is around privacy breach reporting, not security, privacy breach reporting. And worth noting, the definition of a privacy breach in the New Zealand legislation is subtly wider than that in the Australian legislation. So if you're an organisation that already has mandatory breach reporting for Australian law, you will need to widen that up. And in terms of what is notifiable, not everything is notifiable, first of all. In order to be notifiable, it has to have caused serious harm or likely to do so to an individual. So there are some things we think about when we think about serious harm. The nature of it. So what's going to happen to someone? Is someone going to be killed? Are they going to have identity fraud? Are they at financial risk potentially? Blackmail? All of those sort of implications to people. Now, at no point in this conversation do we consider what the harm to the organisation is about having to notify about that breach. The barrier for harm is all about the impact on the individual impacted or affected by this breach. But also, when we think about that breach and when they consider is it notifiable, we also think about what kinds of data is it? How sensitive is it? Also, is it already in the public arena or not? And have we got security measures around it? So, for example, a breach of encrypted data without the key is pretty useless. No one's coming to any harm from that. So, what is the actual impact on individuals? Now, unlike GDPR, which mandates a 72-hour time frame to report a breach on, the Privacy Bill hasn't been explicit about when we need to notify. However, it does have one of these slightly fuzzier phases, as soon as practically possible. Okay, so that does not mean in 6 weeks' time. The general expectation is that usually means on the next business day or the one after. And we need to take consideration for what is the impact on people if we delay on that. Now, we're saying one of the additional new fines that the Privacy Commissioner can bring against someone is for delayed notification. So there is a balancing act about how long do you wait, how likely is he to fine you for being too slow. And the other piece that comes into this is about notifying those impacted individuals. Now, that notification to those individuals concerned with the breach needs to be so that they can understand and protect and safeguard themselves from further harm. And if you can't get hold of them, then that is okay. The Commissioner made provisions for that in the bill, and they are able to mandate that you do a public notification. So you will be the person who has to print in the Herald all about your breach, tell all the newspaper people, etc. It's not a place you want to be. And in terms of that breach and that notification, as I said, there are fines if you are slow or fail to notify, and those fines are up to 10,000 New Zealand dollars. And it is the responsibility to notify of the organisation whose data it is. So, for example, if it is our company's data, we collected it about people who we do business with, then it is our responsibility. It is not Microsoft, who are a processor or an agent to us, but ours ourselves. What this does mean is if there is going to be a large breach of one of those vendors, then the regulator will get multiple breaches all about the same thing. But the reason for that decision is that the organisation whose data it is will know most about the harm that it's going to do to people. Other things that are changing. The introduction of compliance notices. So a compliance notice is a document that you are issued that describes what part of the Privacy Act is believed to be breached and what you need to take as an organisation to remedy that breach. Now, as well as that, the Privacy Commissioner can put conditions on your business until that breach has been dealt with. So worst case, the Commissioner can actually say you cannot offer a service, or maybe you cannot offer one of your sales opportunities, etc., until something has been dealt with. So this can actually really hinder your business from thriving. On top of that, the Privacy Commissioner is obligated to publish these notices unless they can show there are significant harm to the business outweighs the public interest. But the default is that they will be published. So they will be there as a matter of public record for people to see what the challenges are, etc., with your organisation. There are some additional steps that you can challenge that notice if you require. You've got 15 days to do that. So it's a very short period. The other thing is that new criminal offence has been introduced. So there is now an offence for destroying personal data solely for the reason of not wanting to give it to someone as part of a Privacy Act. It goes without saying it's just unethical anyway. It is also an offence, and they have re-clarified this, to do things like obstruct or hinder the Commissioner. So, in all honesty, most probably the compliance notice is of much more harm to your business than any fine that you're going to get for lack of notifying of a breach, and much more inhibiting to doing your business. Now, the Privacy Bill has clarified the role of an agent of you. Now, an agent is someone who acts on your behalf. So it might be Microsoft, it might be Xero, but it could also be the mailing house that posts your letters on your behalf, or the company who does your doorstep questionnaires on your behalf. All of these are your agent. They collect data, they process data, or they do something with your data for your company's benefit. And most organisations will have somewhere 900, 1,000 of these organisations around that process or deal with data on your behalf. Now, the Privacy Bill has confirmed that you are responsible for the actions of all of your agents. So if it's your data, end to end, you are responsible for it. And it is not a disclosure under the Privacy Act if that information is given to that party to do what you ask them to do. However, if that third party subsequently uses or discloses that information for their own purposes, then they stop being your agent. So, some common scenarios we see, they are using the data to create a statistical norm. They are using it for product and service improvements in an identifiable way. All of those are not for your organisation's benefit, they're for that third party's benefit. And that would therefore be a disclosure. Now, most of those disclosures occur, not surprisingly, when you are the product of that service. So if that service is free, then likelihood is there will be some use by them for their own benefits. So that brings us on to the additional next step. So previously, under the Privacy Act, we had 12 principles. For good or bad luck, they have decided we're going to add another one. So we're going to have 13. But instead of adding it as a 13th principle, we are going to move the principles down one, and we're going to add a new principle 12. Now, this principle is about how we share data overseas, but it only applies to disclosures overseas. So, as we said earlier, if you give your information to Microsoft to host in their data centre in Australia, that is not a disclosure. This principle does not apply. But if you give your information to Trello and you are using the free version and they are using it for their own benefits, for commercial gain, for example, then that is an overseas disclosure. Now, if you have an overseas disclosure, there are additional steps that need to be taken. So, in terms of allowing that disclosure, there are 5 key things that must happen. It either, the party you're disclosing to must be subject to the Act, to the New Zealand Act. And we'll talk a bit more about why that's important in a bit. Or they are subject to privacy laws that are comparable to our own Act. Now, one of the things that has been allowed is that the Privacy Commissioner, along with the Ministry of Justice, is going to issue a list and regulations of those laws that are equivalent. The expectation is that it will have things like GDPR in that list. And that list is hopefully going to be available in the next month. The organisation may be subject to a prescribed binding scheme. Now, commonly binding schemes are things like the Privacy Shield, for example. And again, that list will be available. The further one is that they are in a prescribed country, so a safe country that has comparable laws to New Zealand. Again, that list is not yet available, but it is expected that that list will contain those same countries that are deemed to be comparable for GDPR. So that is Japan, Mexico, Uruguay, etc. Now, worth noting, that list at the moment for GDPR equivalency countries does not include Australia. And the reason for that is that Australia's Privacy Act only kicks in once you are earning over a certain threshold. So there are a whole bunch of organisations and businesses in Australia where the Privacy Act in Australia does not apply to them. And that is why they never got that level. So it is yet to be seen whether that is deemed to be appropriate for New Zealand. The last one we can do is that they have an agreement that is subject to New Zealand law or the Privacy Act, or additional contractual clauses have been put into the contract to provide the same level of cover. And most of that will be provided as model clauses from the Privacy Commissioner. So they are going to be issuing those that you can slot in the back of your contract. But before we all rush out and put those in the back of our contracts, the easiest way of dealing with this principle is not to have them use our data. So we might add a clause in our contract that says, for avoidance of doubt, you are our agent and you must not use our data for anything else other than what we wanted. Therefore, this new provision does not apply. But there will be substantial work for organisations to establish what overseas disclosure are they doing, what do those commercial arrangements look like, and what of these new provisions are going to take effect. Now, we talked earlier about this extraterritorial piece. So one of the things that has happened as part of the Privacy Bill is they have clarified and expanded the extraterritorial effect. So that means when the Privacy Act applies to companies outside of New Zealand, by default, every organisation in New Zealand applies to, unless you're in the exemptions, and that's very few. In terms of overseas businesses, it's ones carrying out business in New Zealand who will be subject to the New Zealand Act. Doesn't matter if they have a physical presence in New Zealand, but if they are carrying out business in New Zealand, then they are deemed to be in scope. So for example, that includes Google, Facebook, Microsoft. They are all doing business in New Zealand, that therefore brings them into scope. But it also brings a lot of Australian companies and organisations into scope. It also clarified an existing requirement. So already in the law as it is today, every organisation is required to have a privacy officer. So unlike things like a CISO, this actually has to be an appointed person, and it is required by law. Now, what it has clarified is that the privacy officer does not have to be your own staff member. You are allowed to outsource that responsibility. As long as your organisation has a person that is meeting the requirements of that role, which is about promoting privacy compliance within your organisation and monitoring your level of compliance, then that is enough for your compliance there. And it is really common in New Zealand at the moment that lots of organisations don't have a privacy officer. So they're not currently meeting the requirements of the existing Act, never mind the new one. For those people who do information sharing, particularly across government, they have changed the information sharing provisions in the new bill. So, whereas we used to have the ability to have information matching agreements and information matching programs where bulk data would be compared between two government departments and a match done, those provisions are going away. So if you have an existing information matching program, and there are many of them, 30 to 50 of them, those will be grandfathered to become an approved information sharing agreement. Now, going forward, if you need a new one of these things, then it needs to be an approved information sharing agreement, an ASA. And those involve 3 trips to Cabinet and about 18 months to get one. So that is quite a substantial change if you are one of those organisations who thought they were going to use those provisions or is going to need to change those. Also, some other things to note. They have changed the rules around collection from children. So what they have added in is some additional provisions around having to give thought and consideration when collecting information from children. And that's about their vulnerability. So not to force or entice children to give more information than required, but also to think about how do you give a privacy notice for a child. So if your privacy notice looks like a lawyer-rated dictionary, then it's unlikely that a child is going to be able to understand or comprehend what's happening with their personal information. It has also added in some extensions to the exemptions to who the Privacy Act applies to. So it is extended, and the Privacy Act does not apply to RNZ and TVNZ now. However, they were always subject to stronger requirements anyway because they were a government entity. In terms of the other changes as well, there are some subtle changes to unique identifiers. So these are numbers that are issued that allow you to search for someone. There has always been a provision around unique identifiers, but they have added to those to say that you must take additional steps to make sure that you don't issue more than one unique identifier to any one given person. So this is about preventing identity fraud. And also, if you are sharing those unique identifiers, and that is quite an unusual case, then the risk of misuse of that person you're sharing it with must be considered about whether you should share that or not. So that means things like when you are asking for people to provide their driver's license number, their passport number, etc., you need to give consideration for the risk of misuse of that information. Now, in terms of that, it is worth as a reminder, all of the current provisions in the Act, with the exception of the information matching agreements, still apply. So the other 12 principles we have today in the Privacy Act still apply. So we must still give privacy notices to people before we collect their information. It must still be secure. We mustn't hold on to it for longer than required. And we must only collect and use and disclose the information that we need for the purpose. And a lot of organisations today already have issues around compliance with the current Act. So the uplift for the Privacy Bill is a step up from where we already are. But as I say, a lot of people are not already compliant. So how do we make sense of all of this? The first thing is not to panic. It's to get the basics right. So looking at how do we collect data, how do we use it, but also thinking about how do we bed in things like privacy impact assessments into our business to ensure that we remain compliant. So some key things we might be looking at is updating our internal privacy policy that we use for our internal staff to reflect maybe things like what data should we be now storing offshore, or what additional checks do we need to build in for our new third-party vendors. We might need to update our vendor contracts, or I can pretty much guarantee you're going to need to make some significant changes to a lot of your vendor contracts. you may need to update your privacy notice. And the reason for that is, as you work through your overseas disclosures, it is very likely you're going to identify that you have way more disclosures than you ever knew about. And each of those disclosures needs to be included in your privacy notice. So the act of working out those disclosures will result in you needing to update that privacy notice. From an operational point of view, you're going to need to update or elaborate on your breach notifications. You're going to need to have additional steps to allow notification to the Privacy Commissioner, to the affected individuals, and work out within your business who's doing that, whose responsibilities, and what templates we're going to use. Also thinking about those changes, as we said, for your privacy impact assessments. Now is a good time to start and assess new projects coming through for compliance to the new Act rather than the old one, so that you have less work to do that uplift. But the key thing across all of this is about raising awareness within your organisation. So, how do we convey that things are changing in the Privacy Act and we need to start and consider those? So that might be things like refreshing our privacy training programs, sharing details about the upcoming changes with our team, or doing scenarios such as breach scenarios testing to make sure that we understand those additional steps we have to do. And across all of this, it is about how do we design privacy into stuff as the default. So how do we think about privacy early on in our projects? So Chris spoke earlier about the privacy training he'd been on. That is all about designing privacy into solutions so that when we get to the end of it and we do a check against the Privacy Act, that we don't have gaps in our solutions. So in terms of planning for that, one of the key things we have and available for free is that ability to do a readiness assessment. And that is a cross-check across your business to see how you are going. And that one of the things that you will find as part of that is it quite often, as I say, shows up that current lack of compliance with the Privacy Act. And then it is about having a risk-based discussion with your business. If you are not currently compliant with the Privacy Act, as it stands today, the workload to get compliant by the 1st of December may be great. So you may need to prioritise which items you need to address first. In terms of that, also, things like infographics. So this one is available, download on a website. It is a pictorial that can help your project teams develop and work out what needs to happen ready for the new bill. And it also includes details of all of the existing provisions as well, for you to be able to cross-check those, etc. Just as Chris said, there is training available if people want it for technologists about it. But going back, privacy is all about trust. And as we said, the Privacy Act and the privacy expectations of people are changing throughout the world. And New Zealand is just catching up in terms of where the rest of the world has gone. We were a forefront of privacy, and slowly over the last 25 years, we have slipped back. So we are just catching up again to the rest of the world. If we don't catch up, it has great implications to our trade, for example. So one of the things this year that is happening for New Zealand is we are being reviewed as a country to see if we can keep that very special status with Europe, to keep that adequacy to allow transfer of data to New Zealand without hindrance. So if we don't change our Privacy Act and don't get to that bar soon, we will lose that, which will have huge impacts on our SAS providers predominantly in that area, but also other businesses around it. So hopefully that today has given you a bit of an oversight into what is changing. And as Chris said, breach is one of those items. but it is one of a number of items for it. So what we'll do is going to open up the deck, and open the floor up, and I'm going to answer some of the questions. So some people have been asking questions as we go along, but feel free to chip in more as we go. So I have now allowed you guys to unmute yourselves, so please go easy. So someone asked, when happened to the 19 principles we had earlier? So on one of the earlier versions of the Privacy Bill, we did have 19 principles. What happened was that 19 was deemed to be rather unruly. So when they actually looked at them, they pared them back and they said, look, most of these do roll up together and they roll back to actually one of the existing principles. So they took it back and just put it back to that 13. The other thing that happened is some things that have been campaigned for, like the right to be forgotten, that happens in Europe, has not been included in the New Zealand Privacy Bill. So we have not got that whole way to the equivalency with Europe. Okay, it's not gone as far. And part of that was about the impact on New Zealand business and New Zealand organisations to make that shift through. Consequence of no data sharing with Australia in certain circumstances. My belief is we will still continue to have significant data sharing with Australia. A lot of our data sharing with Australia happens as a fact they are our agents anyway, so a lot of it is excluded. But in terms of things like data sharing for law enforcement, etc., that can still go ahead with Australia. But the contract or commercial agreement will need to have those additional clauses in place possibly. Or Australia may need to become part of that list of approved countries. In terms of that though, I don't think it is going to change significantly what data goes to Australia. What I do think it will do is make people focus and think about what of their data are they giving away as free as part of using tools or solutions, etc., that maybe they want to draw back on and not have those disclosures, etc. In terms of ACEs and applying to banks, so ACEs have a unique place in legislation. They are only there for providing a public service. So they are allowed to include private entities like banks, but they have to be for the public good and they have to be led by a government entity. And usually that has to be a government department or one of the approved additional lists, which includes DHBs are allowed to lead their own. So if one of the ministries or departments makes a case for needing that cross-sharing, then they will be able to lead that. And the banks are able to join that arrangement as long as it is for a public good. So that would most probably require one of the larger institutes, etc., to lead the charge. Now that may well be Treasury in order to do that cross-sharing for open banking. In terms of digital and identity initiatives and the trust frameworks, that work is still going ahead. However, part of that work is looking at what is the legal basis to enable those to happen. Now, nothing in the Privacy Act takes precedence over an individual act. So it may be that that digital identity initiative or trust frameworks may end up having to have their own piece of legislation or one of these ACEs to enable it to work outside of the bounds of the Privacy Act. So it is not saying you can't do it, it is just saying that there will need to be some additional legislative work potentially to enable those to happen. In terms of qualifications, there are sort of two technology-focused privacy qualifications. There is the IAPP CIPT, which is the one I discussed earlier. That is an internationally recognised qualification for the Institute of Privacy Professionals, and it has been around for many, many years. It's just had a refresh for Privacy by Design. The other one that has come out in the last couple of months is the ISACA privacy qualification. At the moment, if you can prove your previous experience, you are able to get that. Feedback I have received on the market about it at the moment is because at the moment there are limited checks and balances about who can get one, that the value is maybe not seen as much. It is also at the moment not recognised by a number of the regulators in the privacy space who require certain roles to be qualified. So for example, in GDPR, you are required to have a certified and experienced and qualified privacy data protection officer. So that is a step up from our privacy officer. And a number of the countries have prescribed lists of what qualifications they see that person as having. Unfortunately, at the moment, the ISACA one from the recent list I have been checking for some of the European ones has not yet made that to the list. In terms of questions about how are OPC going to enforce this? So OPC are getting a few extra staff, and by that I last heard it was about 3. Okay, so they are not going to be there to be coming around doing spot audits of you or checking out what you're up to. They do not have enough resource for that. What they will be doing is looking at things that are driving complaints to them, breaches, or things that are hitting the public domain that they think has something awry with it. So unless you have got your flag up, waving it around, saying, come look at my great breaches of the Privacy Act, they are unlikely to be coming to just focus and admire your privacy in your organisation. So the key thing, if you don't want to get their focus, is to get the basics right. Do what the customers or the users expect so that they are not going to be complaining to the regulator. And don't try and push the bounds of socially acceptable. In terms of GDPR, someone has said it is dynamic. So in terms of that, the GDPR hasn't changed substantially since it went in. Unlike the Californian Act. The Californian Act changes nearly every week as they're writing it as it goes into force. There is an expectation that unlike this time round, we will not wait 25 more years to change our Privacy Act again. But also, we have written our Privacy Act in a way that it is principles-based. So it does not tell you what level of encryption, what kind of encryption, etc. you need to have from a security perspective. It doesn't detail that. What it says is you have to make a risk-based decision based on the information you have to keep it secure. So if you can demonstrate that you have done a risk assessment and you have worked out the appropriate controls based on the information you have, and you still have a breach, then you are unlikely to get pulled over the coals about it. The people who are likely to get hauled over the coals around Principle 5 are those people who had complete disregard. So for example, who didn't encrypt stuff. It's kind of an industry norm now, so we need to have those things in place. In terms of SAS providers and about checking for adequacy about it, that adequacy was due out in October this year. Now, due to travel limitations at the moment and COVID, it has been delayed. My last update on it is it's expected in most probably January time at the moment. And what they have told New Zealand government is if we do not update our act and get it into force, then we will be assessed against the previous act. And they have already indicated that if that is the case, we will likely lose that adequacy status. So if you are one of those SAS providers, etc., then you are needing to keep an eye on what's going on with that and what is coming out of Europe around that. So that is something that your privacy officer or your data protection officer, as a lot of those SAS providers have, will be keeping their finger on the pulse and seeing what's going on in that place. in terms of privacy officers, so privacy officers, you can have your own one. If you do not have one, you can rent one. So for example, ourselves, we can come and be privacy officers for people, or one of your other outsourced providers may provide that to you. But you do not have to do that if you do not have the skills in-house yourself. So in terms of OPC, so they're looking for smoke, you're right. They're going to look for smoke to direct their efforts there. What it does mean, as you say, is there are going to be potentially people who are trying to point to your smoke which isn't rising. The key thing is the regulator is not, the regulator is wise to this, and they're wise to this game. So if you get someone pointing you, going, they're non-compliant, etc., the first thing the regulator is going to do is ask you about your compliance. So if you've got all of your work done and you can show it, you have nothing to fear. In terms of that, therefore, you know, if there's nothing to hide, you have no problem. But it is about getting yourself in that position where you are ready to answer those questions and be hauled up. The same as at the moment, the regulator can come and investigate if somebody complains to them already your compliance level. This is not a new provision. The only difference is that now the regulator, the Privacy Commissioner, can come and investigate without someone complaining to them first. In terms of how the complaints work, so you can complain to the Privacy Commissioner, first of all. The Privacy Commissioner, however, though, cannot fine organisations for complaints. Okay? If money needs to change hands, then it goes to the Human Rights Tribunal. Now, one of the things that has happened is the Human Rights Tribunal has increased their fines that they are able to give. So it is now up to $350,000 per person. That is an uplift onto what it used to be. But also, the Human Rights Tribunal tend not to award those maximum fines. It is about a fine proportional to the damage or to the harm that has come to that person. Okay, if you've managed to murder someone due to your disclosure of information, then absolutely expect to receive one of those fines. But for most people, it is about identity fraud, etc. So if you have provided credit reporting and a new credit card and a new driver's license, and you have done all that, that fine is unlikely to be that substantial. The other thing that has changed for the Human Rights Tribunal piece is people are allowed to take class action. So previously, you used to have to take an individual case. Most people in their own right would go, well, I can't afford that, it's too hard, I don't want to do it. What has happened is that the new privacy bill has allowed people to bring a class action, so very like the US. So you can group together and go in as a group. Now, what it means, therefore, is as a result of a breach, for example, those people impacted by the breach could group together and bring a class action. In terms of likelihood, however, in 2021, I don't see it happening. For a couple of reasons. The tribunal is pretty backlogged, but also they try and push things to the Privacy Commissioner first to deal with. Okay, so they have a threshold for actual harm, and they use that tribunal for significant cases, or for ones where they are setting a legal precedence. It is not there for everyone to go to get their $3 because they feel that their privacy has been impinged upon. Okay, there is a significant bar before that Human Rights Tribunal are going to be coming for you. But those fines do apply for everybody, and as they do today. So if you're a government entity, you can still be fined both under the Privacy Act and by the Human Rights Tribunal. So you can't sit there and think, oh, I'm government, it's sweet, it's not me. You can still be fined for that. But also, more importantly than any fine you're going to get, you have things under the State Services Commission, under the fact you're a public service, government expectations on you that you shouldn't be barely scraping by on the Privacy Act. You should be leading the charge. So there are additional expectations on top of that for it. And your minister's shame and pain from your chief executive will hurt you way, way more than any fine that anyone's going to give you. But also the ongoing love and attention you are going to see from the Privacy Commissioner if you keep appearing at his door every week with another breach, another incident. You are going to feel that love. And some of the government departments around town have had a series of that experience from those. So I guess in summary, the key thing is be prepared. Be prepared for the current act. It applies today. You need to be compliant today to the current act, but also think about preparing for the new act. And what does that mean you need to do between now and the 1st of December when it comes into force? And have you got enough time and enough resource to do that work in an appropriate fashion?